So dear students, today we will start learning a new lecture, that is right to freedom of religion, and this lecture covers four major articles of our constitution from article 25 to 28. So dear students, we are starting to learn what is right to freedom of religion. So we must know what a religion is. The word religion is nowhere defined in our constitution, but a German philosopher, Immanuel Kant, has defined religion as religion is the recognition of all our duties as divine commands. He has equated the religion with the recognition of all our duties as divine commands. I told you that Constitution of India does not define the term religion and matters of religion. Hence, it is left to the Supreme Court to determine the judicial meaning of the word religion and in the matters of religion or religious practices, what they are, whether they are justified or not. So, dear students, to profess a religion means the right to declare freely and openly one's faith. Religious practices or performances of acts in pursuance of religious beliefs are as much part of religion as faith or belief in a particular doctrine. Dear students, the freedom of religion in India is a fundamental right guaranteed by Article 25 to 28 of our Constitution. And as you know, that preamble of our Constitution has the word secular in it, and Articles 25 to 28 implies that state will not discriminate, or state will not patronize, or state will not meddle in the profession of any religion. People in India mainly practice few religions like Islam, Hinduism, Jainism, Buddhism, Sikhism, and Christianity. So in India, there are religion specific laws also. Hindus are governed by Hindu personal law, Muslims are governed by Muslim personal laws. But Goa is the only state in India to have a uniform civil code that is known as Goa Civil Code. You see, there is a direct relationship between secularism and freedom of religion in India. And you know, by 42nd Constitutional Amendment Act 1976, the word secular was added to the preamble of our Constitution. And India, being a secular state, its meaning is that it is a no state religion, which means that it follows no particular religion. Or in other words, state shall not protect any particular religion. We have a case decided by the Supreme Court, Ahmedabad St. Xavier's College versus State of Gujarat. It was held by the Supreme Court in this case that secularism neither means anti-God nor pro-God. And it just ensures that no one is differentiated on the basis of religion, eliminating the concept of God in matters of the state. So this is the duty of the state, that they should be neither anti-God nor pro-God, and they should not differentiate between different groups on the basis of religion. Then, dear students, so far as the meaning of secularism is concerned, in SR Bombay versus Union of India, Supreme Court ruled that secularism is a basic feature of Constitution of India. Basic feature. It also observed that religion and politics cannot be mixed together. If the state follows unsecular policies or course of action, then it acts contrary to the constitutional mandate. In a state, all are equal and should be treated equally. Religion has no place in the matter of state. Freedom of religion as a fundamental right is guaranteed to all persons in India. But from point of view of the state, the religion, faith, and belief are immaterial. This was decided in S.R. Bomai's case by the Apex Court. So, dear students, this freedom of religion in India is contained in Article 25. Article 25 of the Constitution guarantees freedom to all persons in India. Not only to citizens, but to all persons. And it provides that all persons in India, subject to public order, morality, health, and other provisions, are equally entitled to freedom of conscience and to have the right to freely profess, practice, and propagate any religion. So your freedom of religion is guaranteed to all persons, not only to citizens, but even to foreigners also. But this right is not absolute one, and this freedom of religion is subject to public order. If by your religious practices public order is being disturbed, your right of religion can be curtailed. If your practice of your religion affects morality, it affects the health, then right to religion can be curtailed. Reasonable restrictions can be imposed on your right of religion, on your fundamental right to freedom of religion, on the basis of public order, morality, or health. And this article further provides that this Article 25 shall not affect any existing law and shall not prevent the state from making any law relating to regulation or restricting any economic, financial, political, or any secular activity associated with religious practice. And B, the parliament is authorized to make law providing for social welfare. Like Sati Pratha is abolished. Somebody might say that Sati Pratha was part of Hindu religion. It was part of Hindu religion, but in the interest of public order, in the interest of rights of the females, the Sati Pratha has been abolished. And no one can say that it is affecting my right of freedom of religion because I am Hindu and I am entitled to Sati Pratha also. Ladies will commit Sati along with the death of their husbands. No, this is not allowed because in the Article 25 itself it is mentioned that Parliament can make laws for social welfare and social reforms. There are two explanations attached to Article 25. Explanation 1 says that the wearing and keeping of kripan shall be deemed to be included in the profession of Sikh religion. Yes, everyone having faith in Sikh religion can keep a kripan as part of religious ceremony. But size of the kripan is not fixed. The kripan may be of 4 inches long or it may be 4 feet long. Yes, there is no size fixed. No size fixed by law. But a Sikh can keep only one kripan at a time as part of his religious practice. For extra sword, he will have to take a license from district magistrate under Arms Act. Only one kripan is allowed to each and every Sikh gentleman and women also. But if they want to keep more than one kripan, more than one sword, they will have to take license. Similarly, explanation 2. In Article 25, 2b, the reference to Hindus shall be construed as including a reference to persons professing the Sikh, Jain, or Buddhist religion and the reference to Hindu religious institutions shall be construed accordingly, meaning thereby that Sikh, Jain, or Buddhist, they shall be treated as Hindu so far as this right is concerned, meaning thereby the Sikhs, Jains, or Buddhists also have a fundamental right to their own religion. Then, dear students, if you read carefully Article 25, this Article 25 guarantees rights to an individual, whereas Article 26 guarantees such rights to an organized body of individuals. Organized body of individuals. And under Article 25, I told you that these rights are granted to all persons and not merely to citizens. And these rights are subject to public order, health, morality, and other provisions of Part 3rd. Further, exceptions are grafted in Article 25, Clause 2 also, on the basis of which the freedom of religion can be restricted. We have a case before us, Muhammad Ismail Farooqi versus Union of India. In this case, Apex Court held that the mosque is not an essential practice of Islam and a Muslim can offer namaz or prayer anywhere, even in the open. This was the decision of the Supreme Court that mosque is not an essential practice of Islam. Then we have another important case, Ramji Lal Modi versus State of UP. In this, Section 295, capital A of IPC was challenged as violative of freedom of religion. And it was held in this case that religious freedom cannot be used as a protection against acts which are inimical to public order, health, or morality. Section 295, capital A of IPC was held to be not inconsistent with Article 25 and 26 because it imposes restrictions in the interest of public order. Section 295, capital A, it makes punishable deliberate and malicious outraging of the religious feelings of any class of citizens by words either spoken or written, by signs or by visible representations, or otherwise if you insult or attempt to insult the religion or religious feelings of that class. So you have a freedom of religion, no doubt, but that does not mean that you will insult the feelings of other religions, because your fundamental right is subject to fundamental right of the remaining society also. And your fundamental right of Article 25 and 26 is subject to other fundamental rights provided in Part 3rd of Constitution of India. Then another very important leading case is Lily Thomas versus Union of India. It was held in this case that if a Hindu gentleman has converted to Islam, he cannot complain of violation of his right under Article 21 if he is prosecuted for bigamy, for contracting second marriage after conversion, while the first marriage before conversion subsists. This was a misimpression among the males that if they will convert to Islam, they will have option of marrying 4 wives. But Lily Thomas' decision is very important, that if your first marriage is subsisting before conversion and now you have converted to Islam, you have married again, it amounts to bigamy. Conversion is no problem. You can adopt any religion of your choice, but you will have to face the charges of bigamy because your first marriage is subsisting. And dear students, this right of freedom of religion is subject to other provisions of Part 3rd of Constitution of India, and it is also subject to public order, morality, and health. So relying on these provisions, relying on Article 25 Clause 2, Supreme Court justified the Environment Protection Rules 1986 under Environment Protection Act, which prohibit noise pollution as regards the use of voice amplifiers or beating of drums by religious institutions. See, I have a freedom of religion. I am propagating my religion. I am exercising my freedom. But when I am using voice amplifiers on the top of the temple or mosque, I am using 4 loudspeakers and disturbing the sleep of other citizens, causing noise pollution. So Supreme Court said that these environmental protection rules, which prohibit the noise pollution by use of voice amplifiers or by beating of drums by religious institutions, these rules are correct, rules are constitutional, but your right to religion has to be curtailed to some extent. You must have noticed in your vicinity that sometimes वो माता का जागरण हो रहा है, पूरी रात जागरण हो रहा है, भजन बज रहे हैं, which is affecting the sleep of other citizens. आप भजन करिए, आप पूरी रात जागरण कीजिए, आप 10 दिन जागरण कीजिए, आपको कोई मना नहीं करेगा. But you should not disturb the sleep of others. By beat of drums, आप होली दिवाली मनाइए, आप ढोल नगाड़े बजाइए, but it should not disturb others. That is the restriction in the interest of public order, or in the interest of morality, or in the interest of public health. अगर आपका रात भर माता का जागरण चलेगा, लाउड स्पीकर चलेगा, so in the vicinity of 5 to 8 kilometers, people won't be able to sleep. You do not have a freedom of religion which is absolutely granted to you. No. So your practice of religion should not adversely affect the rights of others, including right not to be disturbed. Because right to sleep is also my fundamental right, as decided by Supreme Court in Baba Ramdev's case. And then another illustration coming from Supreme Court is again relating to noise pollution. The Supreme Court put a ban on bursting of firecrackers between 10 p.m. and 6 a.m. even on Diwali nights. This was held justified because firstly, the bursting of firecrackers is not essential part of Diwali. And secondly, Article 25 gives way to Article 21. It protects life from noise pollution. I have a freedom from noise pollution as part of my right to life under Article 21. On the other hand, you have a right of religion. आप दिवाली मनाना चाहते हैं मनाइए, लेकिन रात को 10 बजे से सुबह 6 बजे तक आप पटाखे नहीं चलाएंगे. 2 reasons. Right to sleep of others is involved. आप पटाखे बजाएंगे, लोग सो नहीं पाएंगे. आप पटाखे बजाएंगे, noise pollution होगा. आप पटाखे बजाएंगे, obnoxious gases will be produced, environmental pollution होगा. So you cannot play with the right to life of others. You have a right of religion. खूब दिवाली मनाइए, but please do not use crackers between 10 p.m. to 6 a.m. That is a reasonable restriction on your right of religion. Another case, very important one, Muhammad Hanif Qureshi versus State of Bihar. In this case, the question before Supreme Court was whether prohibition of cow slaughter violated the freedom of religion of Muslims. You see, there is a law. You cannot slaughter the cow. And people from Muslim community, they might say that killing of cow on Bakra Eid festival is part of their Eid celebration, and it is freedom of religion. So Supreme Court held that practice of cow slaughtering was not an essential part of Mohammedan religion, and that practice can be regulated under Article 25 Clause 2 Clause A. So, Supreme Court said that anti-clause slaughtering laws prohibiting cow slaughter, they are not in violation of fundamental right of religion of the Mohammedans because cow slaughtering is not a part of practice of their religion. So it can be regulated. It can be regulated by law. So there are laws prohibiting cow slaughtering in our country. And dear students, this right of religion is subject to power of the state to make laws for social welfare. I gave you the example of abolition of sati pratha. I may say, my wife might say that sati pratha is part of my religion and I will go sati on the death of my husband. But the government has abolished sati pratha. Government has abolished the system of Devdasi. And this abolition could be justified under Article 25, Clause 1. That ladies have a right of religion, but ladies do not have a right of sati. Gone are the days when women used to sit on the burning fire of their husband. They have a right of religion, but not right of sati. And sati is legally abolished, legally made an offense. Likewise, Devdasi Pratha is also abolished. And this abolition is justified under Article 25, Clause 1 itself. Then, dear students, next Article 26 guarantees few rights to a religious denominations. Again, they are subject to public order, morality, and health. Three portions are there. One, to establish and maintain institutions for religious and charitable purposes. They have a right to establish and maintain institutions for religious and charitable purposes. Two, to manage its own affairs in the matter of religion, they can manage their own affairs. And third, to acquire and administer both movable and immovable property in accordance with law. Dear students, if you carefully see the bare act of Constitution of India, especially Article 25 and 26, you will come to know that Article 25 guarantees right to an individual, whereas Article 26 guarantees such right to an organized body of individuals like religious denominations. With reference to freedom of religion, we have a very important case of Bijoy Emmanuel versus State of Kerala, decided in 1987 by the Supreme Court. Three children belonging to a particular sect, they refused to sing national anthem Jan Gan Man. According to these children, singing Jan Gan Man was against the tenets of their religious faith, which did not allow them to sing the national anthem. These children stood up respectfully in silence daily for the national anthem, but they refused to sing because of their honest belief in their religion. The headmistress, under the instruction of Deputy Inspector of Schools, expelled these three students from the school. Matter went to the Supreme Court. The Supreme Court held that the action of the headmistress of expelling the children from school for not singing national anthem was violative of their freedom of religion. You see, freedom of religion of those three children was violated by expulsion from the school. And the fundamental rights guaranteed under Article 19(1)(a), that is freedom of speech and expression, and Article 25, Clause 1, freedom of religion of those children were infringed. And court further held that there is no provision of law which compels or obliges anyone to sing national anthem. It is also not disrespectful if a person respectfully stands but does not sing the national anthem. Then this controversy was again on the surface in Shyam Narayan Choksey versus Union of India. It was contended before the Supreme Court that every person must show respect to the national anthem. Cinema halls were directed to display national anthem before and after the movie. Supreme Court held that every citizen or persons, they are bound to show respect to the national anthem of India whenever played or sung on specific occasions. The only exemption granted is to disabled people. Disabled people are exempted from standing up because they cannot. And it was further held that playing of national anthem in cinema halls is not mandatory but optional and directed. Initial order was that each and every cinema hall has to play the national anthem before the movie. But later on, Supreme Court themselves modified their original order, and the current position is that playing of national anthem in cinema halls is not mandatory, but now it is optional and direct. But you cannot punish a person, you cannot expel 3 children from school if they fail to sing the national anthem, because it is their freedom of religion also. If their religion is not permitting singing of national anthem, then they will not sing it, and you cannot expel those children from school for for not singing national anthem. Then, dear students, 2 more articles are involved in this freedom of religion. Article 27 protects a person from forceful payment of taxes and proceeds which are for promotion or maintenance of any particular religion or religious denomination. Suppose government says that Ram temple is being constructed in Ayodhya. So like education says, everybody has to pay 1% temple tax as part of their income tax. No, you cannot say forcefully, you cannot impose payment of temple tax forcefully because it is prohibited by Article 27. And 28 also provides freedom from any religious instructions in educational institutions which are maintained completely out of state funds. If a school or college is completely aided by the state, you cannot give instructions relating to a particular religion in that school or college. And this Article 28 is not applicable to an educational institution if it is administered by a state but was established under any endowment or trust requiring certain religious instructions to be imparted in that institution. Yes, state is funding, but the school or college is maintained by endowment or a trust. Then Article 28 is not applicable. Then religious instructions can be given in such schools or colleges. So dear students, this Article 28 also protects a person from taking part in any religious instructions or attending any religious worship which may be conducted in an institution recognized by the state or receiving aid from state funds, unless such person is a minor. So in that case, the consent of guardian is required. Minor children, they do not have the knowledge what is being taught to them in the schools. And if religious instructions are given, then consent of the guardian is required. We have a very good leading case, DAV College versus State of Punjab. In this case, Section 4 of Guru Nanak University Act was challenged. This section permits the state to make provision for the study and research on the life of Guru Nanak. It was challenged on this ground that since the university was maintained wholly out of state funds, this Section 4 and Article 28 are in contradiction to each other. But this argument was not accepted by the Supreme Court because Section 4 was to encourage an academic study on the life and teachings of Guru Nanak, and which need not necessarily amount to religious instructions or promotion of any particular religion. If Section 4 provides that students will make study and research on the life of Guru Nanak, it need not necessarily amount to religious instructions or promotion of any particular religion like Sikh religion. No. Section says that students can make research, they can study on the life of Guru Nanak. It does not mean that they are promoting Sikh religion. And then a recent judgment in which young lawyers were involved, Indian Young Lawyer Association versus State of Kerala, that is commonly known as Sabrimala decision. See how right to the religion of ladies was protected in this case. A public interest litigation was filed under Article 32 by Young Lawyers Association, challenging the practice followed in Sabrimala temple, and the practice was a custom which did not allow entry of women from age group of 10 to 50 years in the temple. And probably the reason was that women from the age group of 10 to 50 are menstruating every month and they are not so pure to enter the temple. Ladies said, no, it affects our freedom of religion. Even if they are menstruating, they should be allowed to enter the temple, Ayappa temple. So the constitutional bench of the Supreme Court held that this custom, this practice was unconstitutional, and they uplifted the ban on the entry of women, stating that the followers of Ayappa do not form a separate religious denomination but are Hindus, and as such a ban is not essential practice of the religion. So Supreme Court held that this custom, not permitting women from age group 10 to 50 are not permitted to enter the temple, this practice violated the fundamental right to freedom of religion of females under Article 25. So dear students, if I may conclude the lecture on freedom of religion, then I can say that India, being a secular state, provides equal protection to all the religions. Equal protection does not mean that it always aids and promotes its citizens to follow a religion and practice. But at times it means to interfere and bring positive reforms for the betterment of the society. A question which recent judgment like Sabrimala has raised is whether it is necessary for the court to decide the constitutionality of a practice merely to establish a right, even when it does not hurt a majority sections of the society. You see, the ladies in Kerala never protested that they should be allowed entry in the temple. But Young Lawyers Association filed a petition before the Supreme Court, and Supreme Court lifted the ban. Although it was difficult for the state of Kerala to implement this order of the Supreme Court. Even temple management was against this order, and still they are not allowing women from age group 10 to 50 to enter the temple. But this new wave of modernism and feminism has set a trend of questioning customs to establish and showcase the right to equality available to us, available to women as a fundamental right. Women too have a freedom of religion, so why they should not be allowed to enter Ayappa temples in the age group of 10 to 50, even if they are menstruating. So, dear students, thank you very much, and stay back for your attendance.